Today we are going to see about the section 33C of subsection 2 of ID Act and its views by the court judgment actually. The aim of the Industrial Dispute Act is to investigate and settle the industrial dispute. That is to maintain the harmony in the industry. That is the core aim of the ID Act. When the person is having the master servant relationship, actually the master servant in the past British, in the British period, the people will work under the lord, so they will be called as a master and the people working under him as a servant. When we see the employer relationship, there should be there if we call him as a workman. The same thing when a person is performing the various functions which overlap in their characteristics and the nature of main function for which the claimant employed should be considered. See, here the some people will come and go. They will work in the factory for 1 or 2 hours or something like that. So they will not be treated as a workman. They will come as a job contract and they will clear the work like that. And some people will work under the release of for purchase order and something like that. They will not be treated as a workman, and they will not come under the ambit of ID Act. And work is either manual, skilled, unskilled, technical, operational, critical. All these things are available in the Act itself. Actually, those who are in the category of supervisory and manager, they will be out of the ID Act. And there are some exceptions also available when we call them as a manager, but they will work as a operator in the shop floor. So that will also be taken into account when this section 33C2 will under the consideration. And next thing is what is called wage. This is very important for considering this section for claim petitions and all. When we call wage means it should be remuneration capable of being expressed in terms of money. So we should not take the gift presentation and all the other things should not be considered as a wage, and also that should be in the terms of employment. That should be expressed or implied. That can be, and also allowances which are given to an employee for which the employee is earning in on month or like that. That should also be considered as a wage. And the value of house accommodation, and the traveling concession, all these things will be treated the wage under the ID Act. And apart from that, under the section 33C2, these are all the separate provisions which are available under the Act. That is, Workmen Compensation Act, a separate commissioner is there. Payment of Wages Act, the separate commissioner in Tamil Nadu, Commissioner of Labor is there. And the Minimum Wages Act, the claim petition will be different. That will not come under the ID Act. So those appeals will dealt in separate commissioners and authorities, not come under the this section actually, section 33C2. And what is called the labor court function under the Industrial Dispute Act? They are the adjudicating authority, and they are going to vouch whether the things will come under the standing order first, whether that is under the model standing order or certified standing order. Next thing is the application and the interpretation of the standing order. How the standing order consider that matter raised under the dispute. That will be taken into consideration while they are entertaining the petition for claim under the section 33C2. And withdrawal of any customary or concessions or privileges, that will also be dealt under this section. And illegality or otherwise strike or lockout, arbitration references section 10A, under section 33, permission to approve the discharge of an employee, and complaint by aggrieved employee under section 33A. And also they will adjudicate matter under the section 33C2 for the recovery of money through the labor court for computation. They will only compute the whatever money available from the employer to an employee, and they will go in detail as per the settlement or agreement or in the appointment. They are the only the interpreted authority under the with respect to section 33C2. What is called section 33C actually? Recovery of money due from an employer. Where money is due to an workman from an employer under the settlement or award under the provision chapter 5A and chapter BB. This chapter 5A will dealt with the retrenchment compensation and closure compensation, layoff compensation, all these things. And chapter B will dealt with the people, those who are more than 100 people when we are engaging in the industry, and those who are authorized by him writing or not, and even death of the workman will also come under the definition of workman. And his assignee or higher legal error will sue the company for getting the money under this section 33C. From the appropriate government, they will apply, and that will be routed to the labor court if it is necessary for getting the computation of money, and the government will order to collect the money from the employer. So that is the provision under the section 33C. Only the recovery of money from the employer is dealt under this section. And what is the limitation under section 33C1? And this is application. Application should be made within a year, and the application should within a year. Appropriate government can extend the period when it is necessary. And what is called the section 33C2? When a workman receives from employer any money or any benefit which is capable of being computed in terms of money, and in question arises to the amount due as to amount or at which such benefit should be computed. So the labor court is the authority to decide whether the money is due to them, and that is first thing is they will see the nature of employment they engaged, and what is the condition of employment they engaged, and this dispute can be entertained. Then only they will consider this computation of money is to be entertained or not. So that is very clear definition given under the section C2 actually. And section 33C3, for the purpose of computing the money value of benefit, labor court may, if so think benefit thinks fit, appoint a commissioner, and he will assess the things by way of taking evidences and submit the report to the labor court, and the labor court shall determine the amount after the considering report. So the labor court can appoint a commissioner specifically for computing the money and taking the evidences from the employer and the employee. Then they can come to one conclusion by way of considering the commissioner report. That is available under the section 33C3. And what is called the section 33C4? The decision of the labor court shall be forwarded by it to the appropriate government, and any amount found due by a labor court may be recovered in the manner provided for in the subsection 1. So the labor court will direct the appropriate government to collect the money from the employer after getting the report from the either from the commissioner, or labor court themselves will assess the things from the employer and submit the report to the appropriate government for collecting the money from the employer. And what is called the section 33C5, where the workmen employed under the same employer are entitled to receive the money from him, and any benefit capable of being computed in terms of money. So here the labor court will go in depth. Either he will get the leave with wages, or with some other money due to him because arrears of money has not been paid, any increments has not been given. Like that, the labor court can entertain a single petition from one workman for computation of money under this section, section 33C5. So single petition, the labor court will entertain entire claim actually. And what are all these provisions comes under this computation of section 33C2? One is section 25C, another one is section 25F, another one is section 25FFF. That is, first thing is layoff compensation, retrenchment compensation, and closure compensation. That is comes under the chapter 5A. And what is chapter 5B? The same thing is available under the section 25M, 25N, and 25O, respectively, from layoff compensation, retrenchment compensation, and closure compensation. And what is called section 33C1 revenue recovery certificate? The amount due to the workman, a settlement is predetermined and ascertained, can be arrived at by arithmetical calculation or simple sitar verification. And also, the only inquiry that required to be made is whether it is due to the workman or not. Recourse to the summary proceedings under the section 33C1 is not only appropriate but also desirable to prevent the harassment to the workman. So here the labor court surely assess the recovery of money by considering the evidences, taking the evidences, and issue the revenue recovery certificate through the appropriate government. That is available under the case Agencia E. Sicoria Messrs. Fabrical Cosa versus Labor Commissioner and others. So the labor court can assess the things by way of taking evidences from an employee as well as from the employer due to the workman for computation of money. So that is available under section 33C1. And what is the difference between 33C1 and section 33C2? Section 33C1 only dealt with application of the workman himself or any other person or assignee, here in case of death, is satisfied amount so claimed and due and payable to that workman. So it is dealt with who is the workman, whether he himself is affected for deprivation of money, any money, and the recovery of the money from the employer, and or any other assignee or legal heir is capable enough to get the money from the employer. That is dealt under the section 33C1. But in the case of section 33C2, the labor court amount so determined by the labor court can be recovered through the summary and speedy procedure provided by the section 33C1. So the employee need not to approach any other forum. Directly he can approach this under section 33C1, and under section 33C2, the employee will get the benefit after computing the money whatever liable by the employer due to the workman, and they will ask the appropriate government to collect the money by way of issuing the recovery of money and issue the certificate. So that is the exclusive benefit available under the section 33C2. Only thing is the employee has to approach the appropriate government by applying under section 33C1. This is the difference between section 33C1 and section 33C2. And in the case of agency of the same case law, section 33C1 does not control or affect the ambit and operation of section 33C2, whichever is wider scope. So in this case law, the labor court having the enormous power, and they can take the evidences and given the recovery certificate by way of making the order under section 33C1. So the rights conferred under the section 33 exist in addition to any other mode of recovery which is workman has under the law. So if the person is workman under the law, so he can entertain get the benefit under the recovery of benefit under section 33C2. And also, if the employer is not ready to give the money after getting the recovery certificate, he will be punishable under section 29. That is available under the ID Act. And under section 31, Penalty for any other offences. If the employee is discharged without getting the permission from the appropriate government under section 33(2)(b) or something like that, the penalty will be very heavier. And the same things available under section 32 also. And cognizable offences also available and for not paying the money after getting the notices, recovery notices from the employer. And what is called the power of execution under section 11(8). Every award made or order issued or settlement arrived at by or before the labor court or tribunal or national tribunal shall be executed in accordance with the civil procedure code section 21. So the labor court is having the authority like a civil court by issuing the execution order. So execution order means the labor court is having the enormous power like civil court to collect the money from the employer after issuing the recovery notice from the appropriate government under section 21. So the equal power is having like a civil court of labor court. That is under section 11(8) of civil procedure code. So the labor court is a civil court having the jurisdiction, and such a civil court shall execute the award and order or settlement if it is a degree passed by it. So this is like a civil court, labor court having the civil court jurisdiction to issue the execution order to collect the money from the employer under section 33(c)(2). Advantages of section 33(c)(2). There is no limitation, no court fees. Any legal hirer or ex-workman can also file joint petition in respect of more than one petitioner. So the many people can join, and if it is the closure company or retrenched many people, they can approach under section 33(c)(1) and get the benefit under 33(c)(2) for retrenchment compensation as well as the layoff compensation, even for closure compensation if it is a illegal one. And material benefit can also be computed in terms of money. No technicalities available in this section. And coming to the limitation, Indian Limitation Act is the only deals with which applicable to court, and that labor court is not the court within the Indian Limitation Act. So labor court will not come under the Limitation Act. That is available under the case law of Nityananda M. Joshi and others versus LIC in the year 1969. And the computation in terms of money of any benefit is covered by section 33(c)(2). The first part is concerned with the money claim simpliciter, and the second part speaks about the computation of money, any benefit to which the workman is entitled. The first thing is how much is the money is due to the workman, and where the monies are lies with the claim. Actually, there are two things will be dealt under the section 33(c)(2). That is dealt in the case of Namor Ali Sautri versus Central Inland Water in the year 1977. And the scope of section 33(c)(2). On fair and reasonable construction of 33(c)(2), it is clear that if the workman right is to receive the benefit is disputed, so the labor court will deal the matter surely if the workman is deprived the right under the claim. So that is the purpose of this section, and the labor court inevitably has to deal with the question as to whether the workman has the right to receive the benefit. If the said right is not disputed, nothing more need to be done. So there is no dispute for claim or entertaining the claim. Under this section, labor court never deals in this matter. Actually, the labor court can proceed to compute the value of benefit in terms of money. Actually, they doesn't deal about the any kind or something like that. Labor court can proceed to compute the value of benefit in terms of money only under section 33(c)(2). And the next thing is the labor court is the given power to allow an individual workman to execute or implement his existing individual rights. So the individual right retrieval will be dealt properly under section 33C2. It is virtually exercising execution power. So here labor court is not only doing the reviewing the proceedings or reviewing the settlements or awards, anything. They will direct the employer through the appropriate government recovery of amount due to an employee by way of execution order. So they are having the execution power under section 33C2. It is well settled that it is open to the executing court to interpret the degree for the purpose of execution. So they will interpret the degree. Degree means the civil court normally issue the degree instead of having the award or something like that under the labor court. Most of the adjudication court will deliver the award and other thing. Here, civil court is issuing the degree because the monetary matter is available under section 33C2. The execution court cannot go behind the degree, nor cannot add or subtract from the provision of degree. So the executing court cannot go behind the degree. So they will not begin the beyond the degree which is delivered by the labor court. These limitations apply also to the labor court. Like the execution court, labor court also competent to interpret the award or settlement on which the workman bases his claim under section 33C2. Here, there are in many areas, we will miss the payment of amount to an employee, and also in the computation also we will miss the something, like some companies are paying the money by way of leave with the salary in basic and DA. Some companies will pay basic DA HRA, and some companies will pay gross, and some companies interpretation is different for leave with wages because they are not taking into account of accident. If an employee met with an industrial accident, they never pay the leave with the salary. That will all considered by the labor court while they are entertaining the benefit for the employee under section 33C2. That is the interpretation thing under the award and the settlement. For the purpose of making necessary determination under section 33C2, it would be open to the labor court to interpret on award or settlement or the workman rights rest. So here the workman rights will be protected by the labor court while considering the section 33C2. And also here, if the set right is disputed, the labor court must deal with the question and decide whether the workman has the right to receive the benefit only if the labor court answers to this point in favor of the workman. Next question of making necessary computation can arise. So here, in the case of Central Bank of India versus Rajagopalan, the labor court first they will entertain the petition only after ascertaining the facts under section 33C1. Then only they will go for the section 33C2. So here the employer must see to that. First we have to see whether this person is a workman. Next thing is any award or any settlement is due, benefit is due for him. Subsequent to that, this will come under the wage or something like that. Then only the labor court will taken into consideration for computation. So the employer should oversee their awards and the settlement while they are drafting. Some of the things we are bringing into the that is wage settlement. That is not right as per the section 33C2. After some point of time, if we deprive the benefits to the workman, then they can approach the approach for the benefit under section 33C1, and they will get the benefit under section 33C2. The case law is available here. The Central Bank of India versus P.S. Rajagopalan. And the benefit enforced under section 33(2) of the Act, it's a pre-existing benefit or one flowing from the pre-existing right. See, here the pre-existing right means some of the things. Say, for example, we should not engage the child labor, the equal remuneration to be paid, and we should not cut the increment. These are all the things will be considered as a pre-existing benefits. First, they will see whether this is the pre-existing benefit or from one flowing from the pre-existing right. So these are all the things they will see into consideration while they are arriving the computation of benefit for an employee. The difference between the pre-existing right or the benefit on one hand and the right of benefit, which is considered just fair, and the other hand is vital. That is available under the sections State of Uttar Pradesh versus Brijbal Singh, and the case of in the case with the Supreme Court of India in the year 2005. And the scope of section 33C2. If approval under section 33(2)(b) is not given, in some of the cases, the employer terminated an employee by way of discharge or dismissal. After that, they will apply for approval under section 33C2. The section 33(2)(b). If the approving authority has not given for the discharge or dismissal, then the employee can go and knock the door of labor court and get the reinstatement. From the date of termination, after we file the case against the government, we can file the writ petition before the labor court, like that. Subsequent to that, if the reinstatement award has been given by on labor court under this section 33C1 and get the benefit under section 33C2, if it is illegal. So that is available in the case of Jaipur Jila Sasakari Bhumi Vikas Bank Limited versus Ram Gopal Sharma in the year 2002. And mere denial by an employer will not oust for jurisdiction. So when the labor court took the matter under section 33C1, if it is valid for consideration to compute the money due to an employer under section 33C2, the employer cannot deny. That is available under in the case of Sagu Minerals and the Properties versus Presiding Officer Labor Court in the year 1976. Here, since the bonus will not come under the ID Act purview, in some of the cases, say for example, in this case, Hamardad Laboratories versus Deputy Commissioner of Labor in the year 2007, a petition has been filed under section 33C1. Then the court rejected their employee plea because the bonus will not the definition come under the ambit of definition of ID Act. So they did not entertain the claim. So the employer should also be cautious while the employee is filing the petition before the labor court. So we can reject the claim when it is not come under the definition of wage. This is all. Claim for back wages cannot be done under section 33(2). Here, the employee has filed the petition for reinstatement in this case law. That is State Bank of India versus Ram Chandra Dubey and others. He only asked the labor court to consider him for the claim petition is filed for reinstatement only. At that time, he is not asked for the back wages. Subsequent to that, after getting the award from the labor court and asked for the back wages under section 33C2 in the same court, and the court has denied to consider this one and asked that person to go in under section 10 of the ID Act. So in this section, they deal only for computation of money due to an employer from employer and the recovery section. This is the recovery section. So denied to accept the plea from the employee in the case of State Bank of India versus Ram Chandra Dubey in the year 2001. And gratuity claim under section 33(2) is not permitted Yeah, in the case law of State of Punjab versus Labour Court, in that where serious dispute exists regarding the basis of claim for payment of gratuity, no proceedings will lie under the section 33 of industrial dispute. So gratuity authority is different for claiming the putting the gratuity claim from the employer. So recovery of gratuity claim cannot be a claim under the section 33 C2 C1. So that is very clear thing is available in the ID Act. So he is not the appropriate authority for settling the gratuity claim. In the case State of Punjab versus Labour Court in the year 1980. And the excess payment during the service error, in this case, Thomas Daniel versus State of Kerala. In this case, the employee had the knowledge of payment received for excess what was due wrongly paid. In case of error detected, corrected with a short time of wrong payment, matter being raised judicial discretion, court may facts and the circumstances, and the employer asked the employee to refund the money whatever the error has done, but the court rejected the plea made by a employer under section 33C1. So employer also cannot approach the court for recovery under this section. Employer also approached in this case Thomas Daniel versus State of Kerala. In the case of Pulchand, Rajasthan State Transport Corporation, Jaipur versus Sri Pulchand. In this case, worker has specifically raised the claim for back wages as well as present supporting evidence demonstrating his unemployment. Court also set various factors for calculating the back wages, which include, among others, the length of service of the worker, nature of misconduct, if any, proved against worker, the financial condition of employer. In the current judgment, existing liabilities in relation to circumstances with back wages can be awarded. And also, in this case, specifically, the court has invoked the Article 142. This is available in Supreme Court. In this case, the employer rejected for reinstatement with the back wages. In the case of Deepali Kundu Sarvas versus Grandi Junior, Atibak Mahavidyalaya. In this case law, the labor court rejected the plea, as well as in the higher court also rejected the plea. But while invoking the Article 142, reinstatement back wages has been given under the law by invoking Article 142. In the case of High Court of Chhattisgarh at Bilaspur, writ petition on 602 of 1998, Mohanlal Jute Mill versus respondents. In this case, the illegality of layoff. Some of the times, the employer used to show the application before the appropriate government, stating that they are the comes under the less than the strength specified under the ID Act, or they can say that we are our financial position and other matters which are enumerated under the ID Act. They will go against the law and they may ask for layoff compensation, and they have not paid the layoff compensation. Subsequent to that, in this case law, back wage, the layoff is invalid and illegal. So the court asked to give the back wages under Article 226 of Article 226 by way of writ petition filed by the Mohan Jute Mills versus Limited versus respondent. In the case of Kanjan Oil Industries Limited versus Sri Ranganatha Shukla, actually in this case, the employee dismissed and filed a reinstatement. The company reinstated with the back wages, but it did not pay the arrears of wage components like VDA, bonus, and other consequential benefits. The company refused to pay the because of these items are not come under the wage definition of ID Act, but the court observed from the award and found these are all the benefits included in the settlement like bonus and VDA. Here in this case law, the court reviewed the settlements and awards signed with the union, and read the settlements and awards, it says that the bonus and VDA to be paid to an employee. So the court observed that writ is allowed and asked to pay with the 10% of interest with arrears in the case of writ petition 3011 of 216 Kanjan Oil Industries Limited versus Sri Ranganatha Shukla and others. In the case of Murarilal versus DGM Limited, here retrenchment compensation as asked by an employee from the DGM Limited. The execution court, the Supreme Court clearly held that labor court has no jurisdiction under adjudicate the dispute of entitlement or basis of claim of workman. Labor court only interpret the award or settlement, so they cannot go beyond whatever set in the award and the settlement. So in this section, the labor court will interpret the award and the settlements and the documents. They cannot beyond the things. So we should be very cautious as an employer while the employee is filing the petition and as well as the making the evidences from the employer. So we should be very cautious while we are reading the DGM Limited versus Murarilal, the year 2015. Labor court is the executive court, as I said already. In this case law, without prior adjudication or recognition of the dispute claim of the workman, proceedings for computation of arrears of the wage or difference of wage claimed by the workman shall not be maintainable under section 33C2. In this section, in the first instance, they have to see whether this petition to be allowed. Then only they will first they have to see to that this petition will come under the section 33C1. Then only the computation to be made. But in this case, the labor court arrived the amount and given the execution award, but the court rejected under the case of Ganesh Rasak and others. And another thing. So there are various acts which are available: Payment of Wages Act, Minimum Wages Act, Motor Transport Act. So the workman may have the forum to claim the amount, the jurisdiction to entertain the claim under section are not barred actually. In this case, there are in many instances, the employee can claim the petition through the Payment of Wages Act or Minimum Wages Act or Motor Transport Act. Through this act, and they can approach the appropriate forum to claim the petition, claim the money. Also, they can approach the labor court for getting the money in the under the section 33C1, and the 33C2. The labor court will review the agreements, settlements, awards, and how the terms of employment is engaged, whether the definition will come under the wage definition or something like that, or any exclusion clause is there, like gratuity, bonus, or some other incentive. All these things will not come under the definition of wage under the ID Act. After that, they will issue the recovery certificate. Further to the in this case, there are so many case laws are there. Legal remedy by preferring the application under section 33C2. Labor court for grand arrears and bonus for the period 11/8/2019 and 31/12/2019. Question: this will come under the ID or Payment of Wage Act or Minimum Wages Act. Send back to the lower court to decide whether this will come under the 33C2. So in this case, that is Dularam Manikrao Hegde versus Sudarshan Paper Converting in the year 2000. Recent case law 2020. The employee has asked for reinstatement with the back wages, that is arrears of wages, and he seeked many things, minimum wages and other things, but the appropriate government has forwarded to labor court, but the labor court again sent back the petition to the claim petition to the government to review. This will not entertain by them. That is under section that is not come under the section 33C2. These are all some of the cases. Because of time constraint, I could not give the explanation. I will share the PPT after this program to all. There are many case laws are there. because these are all the petitions disallowed by the labor court. That is not turnable under section 33C2. They are in various factors actually.